Our next speaker is David King from Bassberry & Sims in Nashville. David's practice includes healthcare and product litigation. He is co-leader of the firm's managed care team, which represents healthcare providers in payment disputes with managed care payers. He also serves as the leader of the firm's healthcare liability team, which represents hospitals and other providers in professional liability actions, peer review matters, and other disputes involving healthcare operations. David also handles product liability and insurance litigation. He will discuss responses to 30b-6 notices, objections to contention discovery, the duty to designate knowledgeable persons, and non-evasively answer questions and more. Please welcome David King.
We all remember the old days of responding to corporate witness deposition requests, and maybe not so old days for many of us. And it's typically you find a witness who has a pretty good appearance, somebody who has a reasonable knowledge of the facts. You prepare that witness as you would any other witness, and then you get into deposition and you shoot from the hip. You deflect any criticism of the witness not being prepared for the deposition. You deal with questions that ask about corporate positions by asserting privileges without really having a sense of what the privilege is, but it just feels right to object. And that's the way that we've traditionally dealt with Rule 30b-6 depositions, at least in my experience. But I have had three experiences that I wanted to tell you all about that have really shaped the way that I've come to really try to follow the rule a little bit better and as it was designed. The first experience was actually 15 years ago. It was a malpractice case in which there was an allegation of an air embolus during back surgery. The hospital had a corporate witness who actually was a nurse, was being deposed. I represented the anesthesiologist, so I was a witness. And what I observed was a 3-hour slow motion train wreck in a witness who had a very difficult questioner asking all sorts of very difficult questions, and it put a little seed in the back of my brain that I ever have to deal with this situation again, I want to be armed for if I'm the lawyer defending that deposition. Well, sure enough, 15 years later, same plaintiff's lawyer, similar case. Now he served me with a 30b-6 corporate witness deposition designation, and so now I have to deal with the same lawyer with a similar circumstance. So I'm going to tell you a little bit about that. I'm also going to show you a few clips from that 1997 deposition where we were able to pull those out of the box. And then the third case that I've dealt with recently is a managed care dispute, and that case involves a situation. It's a very complicated case, $40 million dispute, 5,000 or 6,000 claims at issue with some very overbroad 30b-6 designations that we were forced to have to deal with. So that's kind of the background, but let's just jump into the basic rule before we get into strategy. And obviously, applying Rule 30b-6 and most state rules are similar. The first thing that the entity has to do is designate the appropriate witness. The witness has to have some knowledge, or doesn't necessarily have to have knowledge of the topic, but the witness must testify about information known or reasonably known to the corporation. The testimony of that witness is admissible against the corporation, not necessarily binding, but it is admissible. And what's really important here is some courts have held that if the witness doesn't provide sufficient information on the topic, the witness may be deemed to have not appeared at the deposition and sanctions can be appropriate. So it's very important to have the right witness and have the witness prepared. Some key issues that come up from time to time in this situation. One is from Jim Miller, sent me a case from Florida where it was a situation where the SEC had a lawsuit against a lawyer, and the lawyer tried to take a 30b-6 deposition of the SEC, and there was an interesting issue about whether or not the SEC had to produce a corporate witness. So I've included in the materials the district court opinion that in fact said that the SEC had to produce a corporate witness. The second issue here is the lack of specificity in the request, and that's the managed care case that I have, where you have to really take a hard look at, is the questioning party being specific enough so that you can reasonably respond? And then third, the designation of the witness and the preparation of the witness and what's required there. And then fourth, and this is where you really get into some strategy issues, what do you do when the questioner asks questions about the corporation's positions? So let's talk just a little bit about specificity. The questioner has to give a designation with reasonable particularity. And it's important to dig in. When you get that notice, it's important to dig in and understand are they giving you sufficient information so that you can have the right witness to respond? Examples of overbroad requests, if they just have a general subject matter, that's too overbroad and you've got to do something about it. And then if they have questions like respond to all allegations in the complaint or all responses to discovery, you've got to get ahead of that and not let that just go into the deposition with that kind of notice in play. So here are some examples from my managed care case, and it's a wordy slide, but it just goes to show this is a big case with a lot of issues, and the 30B6 notice had so much information, you would have to have an army of witnesses to produce to respond to this notice. So you've got to find a way to get ahead of that, break it down. You can propose multiple witnesses. You can object if it's overbroad, and just find a way to deal with it. But the key is you've got to do something to be proactive about it. As I said, one way to deal with it is informal negotiation. Try to find a way to reach some agreement with the attorney, but simply do not wait until the deposition to deal with that. That's the old way of doing it and not the new way of doing it. In terms of designating the corporate witness, keys there are the witness does not have to have personal knowledge. Obviously, I think it makes sense to have a witness with personal knowledge because otherwise you're going to be educating somebody that doesn't know anything about it. And I think that's a little bit of a recipe for disaster. The person doesn't have to be a corporate officer, but again, the situation may dictate it. You do have issues about if it's a corporate officer, is that more binding than if it's not a corporate officer? So there's some strategy that's in play there. There's an interesting issue about what if you have a situation involving an older case where you don't have any current employees who know anything about it. The question comes up, is it appropriate to designate a former employee? And some of the cases come out and say that can be appropriate, so it's something to think about. It may be appropriate, as I said, to designate multiple witnesses on a 30B6 notice, so something to think about. And then this was a situation I had in my second malpractice case, is it may be appropriate to designate prior testimony. In my particular case, there were two doctors involved in this case. It's a 3-doctor medical group. One doctor had already been deposed. Second doctor was about to be deposed. And in the middle of that, I was given a 30B6 notice because the lawyer wanted to know what the corporation thought about the witness's testimony. So obviously that was a way just to get another bite at the apple. And I have in the materials a motion to quash that deposition notice. And simply one way of dealing with that is to designate prior testimony as a way to not have to give another witness. So let's talk a little bit about the witness's duty to prepare. The witness must be prepared, must present a witness with responsive knowledge. The responsive knowledge requires the witness to do some sort of reasonable investigation. The witness may have a duty to interview lower-level employees, may have a duty to contact subsidiaries and affiliated companies, and may even have a duty to review documents. So unlike the typical situation where you rely upon the witness's knowledge in the deposition, in this circumstance, the lawyer is actually required to prepare the witness to respond to the questions.
At Centennial Hospital, do surgeons often leave the operating room before the surgical wound is closed and allow unlicensed technicians to close the fascia, the fat in the skin, in the absence of the physical presence of the surgeon?
The physician may make that decision to do that. It is his determination, and I don't know that that's inconsistent with the practice within the community.
Is it regularly done at Centennial?
I would have to say that that would be something that someone who works in surgery on a day-to-day basis would better answer.
Well, if you need to go out and make a phone call to find out, do it. I want Centennial's knowledge regarding that, please, at this time.
I have no interest in making a phone call.
Ma'am, you're here as the representative of Centennial to answer these questions and to give Centennial's knowledge about these issues.
She knows why
I'm
she's here,
sorry.
John.
If you don't have that knowledge, then please go out and find the information. We'll take a recess while you do.
That moment stuck with me for 15 years. How just the importance of having the right witness. She actually did a pretty good job in that deposition, And the lawyer, I think, could have been a little bit more aggressive, but it just goes to show the stakes that are involved in this situation. The next thing I want to talk about, and I've got some more clips coming from this witness, is this, when the witness is asked about the corporation's positions. And that can be, and what we're going to show on these clips, expert opinions. So keep in mind, this witness she's a nurse, she's not a medical doctor, but the lawyer is going to ask about medical opinions about causation, whether or not the case involved, from the nursing point of view, whether or not the nurses should have placed TED hose, which are just pantyhose that are used for to try to prevent blood clots following surgery. And so this corporate witness was asked, well, did the lack of TED hose affect the patient's outcome? And of course, she's not a medical doctor and can't answer that, but the lawyer is going to try to find a way to get around that by saying, well, I just want to know the corporate position. And so you'll see how that plays out. The same thing is true about legal positions. I have a pending case right now where the question is, it's a very complicated case where you've got an issue of whether the hospital is filing an independent cause of action or standing in the shoes of the patients. And that involves a lot of ERISA issues, very complicated issues. And in the deposition, the witness was asked, is it the corporate's position that it's standing in the shoes of the patient or that it's independent? And my knee-jerk reaction, without really doing a lot of research, was I'm not going to let this witness answer this question. This is going to be the subject of a motion for summary judgment, something that requires a lot of legal research. We can't allow the witness to answer that question. And sure enough, there's some research out there that shows that, in fact, is work product, and it's appropriate to have an objection.
Is the hospital going to sit here today and refuse to admit that it failed to carry out Dr. Davis's order?
I have testified to the best of my ability to respond to your question multiple times.
Well, do you know the answer to my question?
I've given you the answer to your question, Mr. Jones, multiple times.
Okay. Look.
Consistently, I believe.
All right, I'm going to give you, to try to find some way to get this answered, a written question that I'm going to ask the court reporter to make Exhibit 1 to this deposition. It says the defendant hospital did not carry out Dr. Davis's orders for TEDS. I've got a block here to say admitted, another block that says not admitted. I want you to check one or the other. Okay. Would you read that out loud so there's no question about what it says, please?
The defendant hospital did not carry out Dr. Davis's order for TEDS. Admit, not admit.
Okay. Would you check the appropriate block to reflect the hospital's position here today at this deposition in that regard?
I will check both blocks, Mr. Jones. I will not check one block.
Okay. However you want to state the hospital's position.
I have stated it multiple times. The hospital cannot evidence by its records.
I'm not asking you about evidence. Would you pass this pen to the witness, please, so she can check it accordingly?
She can answer.
I verbally answered.
And let the record reflect that this witness checked the blocks that says admitted, and she's also checked the block that says not admitted.
All right, so obviously a very difficult question. It's essentially an unanswerable question because the situation was the nurses did not put on the TED hose. The order reflected, the chart reflected that the nurses didn't put on the TED hose, but they said they couldn't testify for certain that they didn't do it anyway. And so she was asked to admit or deny whether in fact they did it, and she just couldn't answer the question. So the question comes up there, what do you do with that sort of a witness? My position would be, I think I probably wouldn't allow that to go on. I would adjourn the deposition and move for a protective order, or more importantly, think about it on the front end and try to avoid that.
Does the hospital recognize that if it fails to carry out physician orders, that the patients may experience life-threatening or life-altering consequences as a result?
Objection to the form.
The hospital recognizes that it needs to adhere to the orders of the physician
Why?
because the physician is directing the care.
Well, does the hospital realize if it fails to carry out a doctor's orders that a patient may die or become paralyzed in some cases?
Objection to the form.
That's very generic. I really have poor comprehension of what you're expecting in response to it.
That is pretty broad, John.
Does the hospital recognize that if it fails to carry out a surgeon's orders for TEDS, that a patient may experience emboli or an embolism as a result and become paralyzed or have lung damage or die or have some other very bad consequence as a result?
Objection to the form.
The hospital recognizes that it has a responsibility to carry out the physician's orders.
Okay. Are you just going to refuse to answer any question I ask?
I'm sorry, but I don't believe that's a refusal. I really am making an effort to answer your questions.
Okay.
So obviously very awkward in that circumstance.
Ma'am, I want you to assume that the hospital failed to carry out Dr. Davis's order and that an air embolism occurred during this surgery. Assume that. It'd be up to me to prove it to the jury, but for the purposes of this question, you assume it. If in fact that happened, does the hospital have any reason to believe that its failure to put TEDS on this patient was not one of the causes of the air embolism?
Objection to the form.
Again, that would not be a decision under the purview of the hospital. The hospital would have to rely on expert witnesses.
Does the hospital know anything about air embolism?
The hospital per se would not be is not in the business of diagnosis and or treatment.
Is the hospital in the business of preventing air embolism from occurring during surgery?
The hospital is in the business of providing nursing care at the direction of a physician.
Okay. I understand that, but I didn't understand that that's an answer to my question. Would you read that back, please?
Is the hospital in the business of preventing air embolism from occurring during surgery?
Objection to the form.
I believe I answered your question, Mr. Jones.
Well, is the answer yes or no?
My answer is that the hospital is in the business of providing nursing care and facilities for physicians and their patients.
Okay. That's your answer, but that doesn't come close to being an answer to my question. Read it back one more time and answer the question, please.
Is the hospital in the business of preventing air embolism from occurring during surgery?
Same objection.
And same response.
Well, does the hospital care if air embolism develops and its patients have air embolisms during surgeries at Centennial?
I don't think I understand your question.
Does the hospital have any concern about whether air embolisms occur during surgeries at Centennial?
Again, the responsibility and the knowledge of that would rely with the physician.
So the hospital just doesn't care one way or the other. It's all up to the physician. Is that what you're saying?
No, sir, that's your testimony, not mine.
Well, what's the hospital's role in preventing air embolism during surgery, if any?
The hospital's role is to provide nursing care and facilities for which physicians render care to their patients, and we provide their service under the direction of the physician.
Okay. You know, you can say that and have it written down, but if it's not the answer to the question I ask, it doesn't count. I didn't ask that. I didn't ask what other roles the hospital has. Read the question back, and we need an answer to this question, please, ma'am.
So what are the takeaways from this situation? First of all, as I said, you've got to be proactive in clarifying the notice, trying to limit it as much as possible. You've got to be really diligent in designating the witness, preparing the witness, thinking about it more than just a regular deposition, but a deposition really on behalf of the corporation. Number three, consider designating prior testimony, as I talked about, in situations where you can hopefully avoid a corporate witness deposition. Fourth, whenever possible, seek, if you don't get in any agreement on the front end, seek to limit it before you even get to the deposition with a motion for protective order, motion to quash, and not expose your witness to what this witness had to deal with. And then lastly, if you do all the things that you think you're supposed to do, and you have a circumstance when the witness just simply can't answer every question, which is very understandable, a way to avoid any potential problem is promptly try to designate follow-up witnesses to fill the gaps and therefore get ahead of any sort of a motion for sanctions. Thank you.